It's to my understanding, sir, that many people do not need to remove their hat.
I'm asking about your situation.
And-
Explain it to me.
Yes, I believe mine is similar because spiritually, I believe I lose power when I expose my head fully. So I'd prefer not to remove my hat because I feel like I need power in here.
All right, leaves Mr. Richmond's two cases, 24M, 2519, 25M, 1312. Mr. Richmond, come on, join your attorney, please. Mr. Richmond, would you please remove your hat in the courtroom?
Like I said earlier, Your Honor, I'd prefer for spiritual reasons not to.
Not cultural reasons.
Cultural are spiritual reasons, are they not? Or spiritual are cultural.
Would you describe that to me further?
It's to my it's to my understanding, sir, that many people do not need to remove their hat.
I'm asking about your situation. Explain it to me.
Yes, I believe mine is similar because spiritually, I believe I lose power when I expose my head fully. So I'd prefer not to remove my hat because I feel like I need power in here.
Okay. I'm going to order you one more time. I do not find that persuasive. In fact, I find it manipulative. I'm going to order you one more time to remove your hat out of respect for the court as I order anybody else so as not to treat you differently. I do not find your reasons to be persuasive. I'm going to order you to do it. And I just wanted to let you know that failure to comply, I will find you in direct contempt of court. Do you understand that?
As long as you feel, as long as you understand, you're asking me to yield my power spiritually in a literal sense. This is what you're doing. This is what you've done last time. This is what you guys always do. And, you know, I think that's really...
I don't understand your answer. I'm ordering you to remove it again with you understanding the consequences. Do you understand the consequences of failure to remove your hat?
Can you please explain them?
Yes, I will hold you in direct contempt of court, finding that after repeated warnings, you failed to comply with the court's order and that it undermines the dignity and the authority of this court. And specifically, I don't find your reason to be persuasive. Do you understand?
Not fully. So do I get to wear my hat next time? That's what I'm trying to understand.
I'm talking about this time. We'll worry about next time. Do you understand that if you fail to comply, I will hold you in direct contempt?
So I'm going to be held for 24 hours while it's cold out?
I have no idea what the consequences are going to be. You will be sentenced on direct contempt, and I'll allow you to make any statements you want in mitigation. I'll hear from your attorney as well, and then I'll decide. You may not go into custody at all, or you may, or there may be some other consequence.
Okay.
What is your response to my final order to remove your hat?
Sir, I really insist on this, and I feel really strongly spiritually about it, and it's time for me to take the consequences of that.
The court has found that now find that the defendant has been warned multiple times to remove his hat. He's been given sufficient notice and given a direct order, in fact, to remove his hat. He is explained, and the court finds it to be completely incredible, having even changed his explanation after talking with his attorney, explained his heartfelt, that's with air quotes, reason for not removing his hat. I find it to be incredible, manipulative, and in direct contempt of the court. I find that it undermines the authority and undermines the dignity of the court. I find that he does so intentionally. And because of that, he is in direct contempt. Regarding the sentence, and I will sentence you in a moment, but let's take care of the pretrial readiness conference piece first, and then we'll talk about the sentence. Anything else on the trials?
No, Your Honor.
All right, that leaves the contempt. Regarding contempt, Ms. Olkowski, do you want to be heard, or you want your client to be heard, or what would you like to do?
One moment, Your Honor.
Yes.
Your Honor, unfortunately, I don't have anything to add to the record.
Okay. Mr. Richmond, you're given the opportunity, and you can just stay right there to tell me anything you want before I decide on the sentence for the direct contempt. If you want to say something, you may. If you don't, that's fine too.
I don't want to say much, but I mean, all there is to say that it's like a religion to me. It's personal. It's semi-parallel to what a lot of religions and cultures believe. And if I embellish too much, then that would be, I believe, wrong.
If you embellish, mean add more to it?
Yeah, like that is part of my belief.
Okay, I got it.
And that is part of, call it spiritual, religion, cultural. I don't care what you call it.
Okay, thank you. I'm not going to call it anything. I will note that you are wearing a traditional black winter hat that shows no signs of any cultural or religious affiliation, nor have you identified any other than a personal belief that you would like to wear a hat to maintain power. Again, I don't find that to be persuasive, as I've already said. Court, again, finding the defendant to be in contempt, direct contempt of court. I'll sentence you to 1 day in the Boulder County Jail. I was considering longer, but I just need to communicate to you that you can't do this, so I don't want to keep you in jail longer. Plus, it's a snowy day, as you said. Perhaps it's not all that punitive based on what you said. So I'll sentence you to 1 day in the Boulder County Jail. Deputies, please. My bigger concern is that we're going to have a jury on Tuesday. I would encourage you to reevaluate your position, because I do not want you to wear a hat in front of the jury and be, hold on, and be in direct contempt again. I don't want that to be disruptive, because that has, here it's just us, but that has the potential to be significantly more disruptive to the proceedings. You don't have to say anything about it at all. I just want to put you on notice that the rules remain the rules. You could talk to Ms. Bukowski about it if you want. You could say something too, but I just might be better to think about it and then talk to Ms. Bukowski. Yes. Yes, thank you.
As far as I recall.
Yes, Deputy, Mr. Richmond, he's going into custody.
Just wait for me, please.
He's been very cooperative with me, other than the contempt piece.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod. All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
What's Goodish, one county prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today? Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time? Yeah, Your Honor, that'd be fine. Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense? Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. He's now retained counsel. To my knowledge, he had no failures to appear. He did failed to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence. I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here. I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you. Thank you. Ms. Gitters, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case. So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority, and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
What is your name, sir?
Whitlock.
Whitlock. All right. Mr. Whitlock, you have appears to be duplicate charges. So some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking, misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not proceed to I do not.
Hold on. So you're gonna hire your own attorney?
Yes, ma'am, I don't consult to the proceedings, and I would like to say things like, I already know how it goes. With the things about crossing guard lines, I'm in a boat, and I was with the officer the whole time. I told them they need to use their cameras here because they found a bud of weed in my boots.
Mr. Whitlock, you say you know what's going on, so you know this is being streamed live. So you
I
don't,
know, but that don't say I'd rather be charged for that than what they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, "Man, this gonna get thrown out," because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here, so when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised, this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings, though, and I do not accept the terms, like,
Okay,
yeah, I
well,
do.
you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man. So
Okay.
that with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, like, I thought I had to deal with Fulton County on that instead of Clay.
Looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like,
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park,
yes, ma'am.
it is on or around July 28th it happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clayton County.
Yeah, the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking. Because I know that's gonna get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not worried about it. I know there's BS. But it's like this one thing. Those charges that I have in Fulton County, those warrants, I had got locked up in front of the legends on Old National. I know this not, I just want you to understand. I got locked up in front of the legends on Old National. I have 2% in the legends. The man even told them, hey, yes, he owner, he's the owner. And they still, hey, let me search you and all that. Now, once they searched and seen I was clear, I'm good. I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm gonna stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and explain it.
I need some professional help. Like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are
You say, talk to my lawyer, right?
Yep.
And even if I say I demand a bond immediately.
What's your name, sir?
I am Moore,
Moore?
special representation
I'm asking you.
Your Honor, his name is Tyrese Breland.
Breland?
That's
Yes,
not my
ma'am.
name.
Oh, Breland.
That's not my name. I'm here on special representation. I'm asking,
Same as last defendant, Your Honor.
my honor, I'm asking,
Okay.
what is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your,
So, Deputy,
Yes, ma'am.
I would like to know your
so
nationality. I
he
would like-
has charges in JOTS and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor,
Is he deputy?
status
Say it
of
again, Your
everyone in the
Is
courtroom.
he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is mental health, or do you think it's just a sovereign citizen?
Can you provide me with the information?
Both. I think it's
Okay.
Can you provide me with the information?
All right, so I'm going to give you your charges.
Charges for what? Are you a U.S. citizen? Are you a U.S. citizen? My honor, are you a U.S. citizen?
Sir, be quiet.
Are you a U.S.
Yo.
citizen?
I said
Said
be
stop.
quiet.
Are you
Be
a
quiet.
U.S. citizen? What is your name? What is your status? What is the status
Yo,
of everyone in the
chill.
courtroom? That's what I'm asking.
All right. So y'all just go ahead and take him back. I'll just go ahead and put you on. Y'all take him.
Feet up.
Asking
Move your
for
feet.
the court to be a jurisdiction of the court.
You might want to chill out.
To be challenged. I'm challenging the jurisdiction of the court. Challenging the jurisdiction of the court because I am not who they say they are. I am challenging the jurisdiction of the court.
No.
Everything should be challenged. I'm challenging the jurisdiction of the court.
Hey, let me get two. Which one's the rest of
Let them know I am challenging the jurisdiction of the court.
State versus Ashley Clark, 22 CR 216, Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
No.
All right, state may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
State of Indiana versus Michael Allegretti, 64 D01 2509 F2 10947. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a FREDA hearing.
It is Ferretta. Mr. Allegretti wants to represent himself. So did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Allegretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
and you will
cannot
have
finish
counsel.
talking.
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that,
Excuse me?
Your Honor.
You are accepting it, sir. You know what direct
I wanted
contempt of
I
court
wanted
is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record.
My
Understand that, sir?
Yes.
What's your address?
702 Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago. Officer Ball, can you give him this? Sure. In that, I wanted to make sure that you were explicitly warned that, well, firstly, I'll consider this conduct during the Ferretta hearing as evidence of an inability or unwillingness to abide by the rules of procedure, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time your lawyer's filing things because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
to
not
that date would
understand.
count. What, did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I have some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes,
of a high school graduation?
yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer though,
I just appointed a lawyer for you.
but I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sir, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
as a result,
I said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay, so I have time that I work on cases. Everything's pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your Honor,
why?
but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in
therefore, it's
equity, Your
legally
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter.
Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all three charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. Do you not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be September 28th of
Understand,
2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah,
I'm just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah,
I'm required to advise you of your various rights in this matter.
am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand you
want- I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No. I already appointed a court-appointed attorney for you because you can't get through the Feretta hearing. You understand why you can't get through the Feretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in pure persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear, because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body and I'm a living human
What does
being.
it mean, sir?
Are you here to practice court? I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen.
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
Trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
And
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
What's your statement?
Why is that so hard to?
Because the first part of your statement, this is a Feretta hearing. I'm here for a Feretta hearing. I've already denied your Feretta rights based on the very first words that came out of your mouth, which was that you're not willing to subject yourself to the jurisdiction of the court. If you're not willing to subject yourself to the jurisdiction of the court, you're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me, what do you not understand?
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Allegretti, is find that you've unduly delayed these proceedings.
All I want to do
Find
is
you in
speak my-
direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor, I
contempt.
have a job.
Please take Mr. Allegretti into custody. We'll try again tomorrow, sir. will be adjourned in F2 10947, and I'll open a new case on the contempt proceeding as required by rule. All right, sir. Lawyers are trained to recognize objectionable and unfavorable evidence and promptly object to their use. They're capable of presenting, as I mentioned, favorable sentencing information and attacking unfavorable sentencing information. In a jury trial, a lawyer will give an opening statement and make a closing argument, and they're capable of doing that very artfully. Have you ever had experience speaking in front of people?
I'm doing it right now.
Have you ever had experience speaking in front of a large group of people?
Yes,
such
I
as-
have.
Okay, tell me about that.
I can't remember.
Okay,
I don't know how to articulate it is what I actually mean.
well, you would articulate it by telling me what experience you have.
I've been in front of people where I've spoke to a group of people before,
How many people do you think were in that group?
at least 25 plus.
Okay, and how many,
It's
how
a
often,
presentation.
how often have you had the opportunity to do that?
More than a handful of times.
How many is more than a handful? 6?
I have no idea. I cannot give you, that would be lying.
Okay. The other thing that a lawyer would do in a trial is help the court prepare jury instructions and select a jury. You understand how to select a jury?
Yes,
What would you do in that circumstance?
I would cross-examine them.
You would. Lawyers have the training, knowledge, and skill at properly preserving the record of a case for appeal. Have you ever been involved in an appeal?
No,
An attorney can also evaluate the strengths and weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement, which might result in a dismissal of some of the charges or a recommendation of a favorable sentence in return for your plea of guilty. This is an important part, and I would ask you to take note that you will, if you decide to not have an attorney, you'll not receive any special treatment with your defense. You'll have to follow all the same rules and procedures in your case as an attorney would have to. The state will have a competent attorney, and they'll have that advantage that an attorney represents for them. If you decide to represent yourself and the result turns out badly, you need to know that you will not be able to complain that you were ineffective as your own attorney in your defense. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more about your skills and knowledge that you have that you believe would be helpful in representing yourself.
where do you want me to begin? Ask me a question and I'll answer it.
I ask you a question, sir. What skills or knowledge do you have that would be helpful to you in this regard?
I'm able to learn quickly and I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs and I was promoted multiple times as team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility and I had to learn fast and move fast.
Have you ever studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast and I only had that job for 3 years. And I was able to propel myself that quickly with the little knowledge I had.
Have you ever studied criminal law?
I'm studying it now.
Have you ever studied criminal law previous to now?
No.
Have you ever had previous experience in the criminal justice system?
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s.
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay. And is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yeah, yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and
Yes.
adjust a lot of information?
Yes.
What about your writing ability?
Yes.
Tell me more about your ability to write.
I wrote up all those. I wrote up all those notices. You didn't read them?
You wrote some documents and
Yes.
filed those with the court on 2 separate occasions.
Yes.
I struck both of those filings from the record because.
Yes. But that's the degree that I'm on.
Okay, so how did you compose those?
I wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make a, I think, fine distinction in Indiana between what are equitable cases and what are cases at law. And this one most assuredly is a case at law. You're entitled to a jury trial. You understand that in an equitable case, you're not entitled to a jury trial? You understand that?
Yep.
You do?
You're telling me now.
Okay.
I'm learning as I go.
Okay. Anyway, so you, along that same vein, had filed some documents with the court. In those documents, you attempted to distinguish between your physical self and a capitalized corporate version of your name, not even your legal name. You understand that the court doesn't recognize that distinction?
No, I do not.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the contrary.
If that's what you're telling me.
Okay. Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me off.
I'm sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
You have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court.
I have no problem.
Within, say, 10 days.
I can do it today.
And then, well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I gave you the notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
Were these charges already filed at that time?
Yes.
You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay. You seem to be clever enough to understand these things. I asked you earlier whether or not you're suffering from a mental health condition. I predict that at a certain point, if you continue to suggest you don't understand simple terms, that your attorney will suggest to me that I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Ferretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana Rules of Criminal Procedure, the Indiana Trial Rules as they're brought into those criminal procedure rules, Indiana Rules of Evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. And then I want to make sure you're clear. The United States Supreme Court has made it clear that the right of self-representation is not a license to abuse the dignity of the courtroom, nor is it a license to ignore the actual rules of procedure. Do you recognize that?
Yes.
You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far, commercial law defenses, or challenging, say, the capitalization of your name, for example.
Do you want me to answer?
It was a question. You
Yes.
understand that?
Yeah.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you've forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the 2 attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case. Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law, and I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L v. State of Indiana, and I think that's an adequate Ferretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert these proceedings. Defendants utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction, attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings. We need to get a hearing on the calendar.
I want to object to your ruling on the record.
So noted. Did you want to add anything to your objection?
I know I can represent myself.